unanimity.
Mr. Mitria.
May it please your lordships, I appear for the appellant with Ms. Berridge to my left. Mr. Khan KC appears for the respondent, and Mr. Armitage appears for the CMA intervening. The question raised by this appeal is whether the Competition Appeal Tribunal erred in concluding that the online sales policy of my client, Deckers, infringes competition law. And we say that the CAT did indeed fall into error. Indeed, standing back, the outcome of this case is wholly counterintuitive. This is a market in which there is vigorous competition between different brands of running shoes, and in which my clients have only a modest market share. And can I just at the very outset remind you of the tribunal's findings on market share? And if we pick up the core bundle to the judgment, so this is core bundle 1, tab 10, page 207. And you see there the tribunal's findings in relation to Decker's market share. You see that at 158.1, and Up and Running's share of the market is at little subparagraph 2. And one of the themes of my submissions will be that having made these findings on the basis of expert evidence, which is addressed over the preceding pages, the CAT did absolutely nothing with that information. It failed to factor it into account. But it's critical information because, as this court knows, competition law is generally unconcerned with vertical arrangements between suppliers and their retailers unless there is market power. And that's because even if those vertical arrangements might in some way restrict competition, including price competition for the sale of that brand, intra-brand competition, that usually does not matter in circumstances where there is healthy inter-brand competition between brands, which there generally will be in the absence of market power. And it's easy to see why that is so. If Hocker's arrangements with its suppliers, if Decker's arrangements with its suppliers are such that price competition for Hocker shoes is suppressed, leading to higher prices for Hocker shoes, then Hocker will lose out on sales to its cheaper competitors, to Nike and ASICS and Puma and Adidas. The normal
Assuming
process,
easy switchability.
something again which just wasn't analysed by the CAT in this case. So the normal process of competition in the market will set to work to discipline the prices of Hocker shoes. So if the price of Hocker shoes is not reduced, Hocker will lose business and ultimately go out of business. And so that discipline that arises from inter-brand competition is sufficient. So competition law generally doesn't need to intervene in these arrangements. Indeed, over-regulation is a bad thing. And it's a bad thing because manufacturers, rather than regulators and courts, are best placed to determine how to sell their own products, how to compete. And selective distribution systems, which is what we have here, are an important means through which brands compete with each other. In other words, selective distribution systems are generally good for competition. They're generally pro-competitive. And we see these principles reflected in the vertical block exemption, which I'll come on to show you in due course. Now, that legislation is intended to be easy to apply. It's a black letter piece of legislation, and it provides for vertical agreements to be exempt from the competition rules where the parties do not have market power. And the regulation provides that that is so where the parties' shares are below 30%. And going back to my Lord's question a moment ago, in those circumstances, you don't need to worry about interchangeability. You're just looking at market share because this is a black letter piece of legislation that is intended to be easy to apply. And the purpose of the block exemption is precisely to prevent over-regulation and to allow firms who do not have market power to exercise their commercial freedom in respect of their own products. unless their agreements with suppliers contain clauses which are overtly damaging to competition, the so-called hardcore restrictions. And if the vertical block exemption applies, then, and this is important, competition regulators and courts do not need to get into any intricate analysis of whether or not an agreement restricts competition by effect, or what's the purpose of this clause. They just don't need to look at that. Or whether the metro criteria, which we'll come to, apply, or why was, as a matter of fact, this clause enforced on a particular occasion. None of that is relevant if the agreement, properly construed, if the terms of the agreement comply with the block exemption. Now, our case is that the tribunal went badly wrong on the vertical block exemption. We say that the vertical block exemption clearly applies to the clauses that were at issue in this case. And there was no need for the tribunal to get into any of its analysis about the purpose of the clause and why it was enforced on that occasion and the impact on price. We say its approach undermines the legal certainty that the vertical block exemption seeks to achieve. And that's our ground 3. Now, the tribunal's error in relation to the block exemption meant that it did in fact address the question of whether the provision in question restricts competition by object. So had it found that the block exemption applied, it wouldn't have needed to look at that at all. But we say here again, it took the wrong approach. And we say that it's rare for vertical agreements to give rise to a finding of infringement of competition law by object. Not unheard of, but rare. And the courts have been very clear that a restrictive approach must be taken to infringements by object, because a finding that an agreement restricts competition by object is a finding, as the courts have said, that an agreement presents such obvious harm to competition that it's unnecessary to consider its effects. So we're looking for agreements that obviously harm competition, so that there's no need for the competition authority actually to carry out an analysis of whether in fact the agreement harms competition. And let's look at the agreement that the tribunal found to be an infringement by object in this case. And it's a combination of clause 15 of Decker's terms and conditions and an email sent by the company's management in 2019. And again, we can take this from the judgment. And if we go to page 134, so Core Bundle 1, tab 10, page 134 of the bundle. So you can see there at the bottom of the page, clause 15. So that says retailer may only sell products on a website it owns and or operates if the retailer has been granted permission to make online sales of products and the website is fully compliant with the company's website requirements as are communicated from time to time, and the contents of the website have been approved in writing by the company. And then that was to be read in combination with an email which you can find on page 154 of the bundle. And that was an email sent in 2019. And it says as follows: the purpose of this email is to confirm to all Hocker customers Decker's policy with regard to the online sale of Hocker products. All accounts are free to sell Hocker on their own websites, which should have a domain name identical or similar to the name under which its bricks and mortar shops, if any exist, operate. If you wish to sell Hocker from a website with a different name, please notify us. It's essential that we have a complete list of all authorised websites selling Hocker. So that's the provision that we're interested in. It's the combination of both of those clauses. And you can see that, in a sense, the email partly supersedes clause 15, and that it makes clear that there is no need to seek permission to operate a website under the same or similar name to the bricks and mortar store. And our submission is that...
Does it supersede it, or is it one of the requirements which are referred to in clause 15 imposed by Decker's? Fully complying with companies' website requirements, and the email's probably just a requirement, isn't it?
I think that's another way of looking at it, my lord. Well, but it does say, the reason I'm hesitating is that clause 15 does say if the retailer has been granted permission, and I think it is to that extent superseded in the sense that this is a blanket permission. And then the requirement that my lord has identified, so the name, that's not an absolute requirement in that you can still ask for permission if the name is not similar. Now, I don't have to submit this, but I would submit that actually, even if this had said, this was a blanket policy that says, well, you can operate under a website with your own name, but not under a website with a different name, that would also be lawful. I don't have to go so far as to submit that, but that would be my submission.
But that's because, on your analysis, however wicked it is in its form, it doesn't have any effect.
Well, it's not even wicked in its form, because it's not wicked in its form. We say it's as, but yes, it doesn't have any. It does not have any impact on competition in the market. But we say it's not even wicked in its form. On the contrary, it's completely innocuous. And the reason it's innocuous is that every supplier is free to sell Hoka shoes on their own websites. So there's no restriction on the use of the internet. So there's no restriction as to the quantity of goods that can be sold on the internet. They can use the internet as they wish, so long as this condition is complied with. And as a matter of fact, of course, nearly every Hoka supplier does have a website through which it sells Hoka shoes. And as a matter of fact, also, Deckers imposes no restrictions on retailers as to the prices they charge. And so, on its face, we say...
that was a finding of fact made by the CAT.
No, my lord, I'm going to come to that. So it's very...
Well, I think it was a finding that there was no restriction imposed on
absolutely correct.
Other retailers, either as to price, provided it was on a branded website.
My lord, that's exactly right. And
it only applies to clearance stock, not other stock.
And there's in fact no restriction placed on the price at which clearance stock can be sold.
There's a recommended price.
There's a recommended
price.
There's
no evidence, I think the CAT said there is no evidence that Deckers has ever sought to enforce the recommended price in relation to anyone other than, on its hypothesis, up and running.
My lord, precisely so. And so what you have in this case is freedom to sell online, so long as the website has a name similar to the bricks and mortar store, no restriction on the price at which you can sell, and a very small market share. And so this is, if I may say so, a classic case. It's very difficult to understand why the CAT went so badly wrong. It's a classic case where there simply is no restriction on competition in the market.
Can I just ask, at
course.
some point, looking at the email, the last sentence, it's essential that we have a complete list of all authorised websites selling Hoka.
Yes.
That would include the list of, as it were, non-retailer linked websites. In other words, what it's saying is, if you want to sell Hoka from a website with a different name,
yes,
please notify us. It's essential we have a complete list of all authorised websites. At some point, can you help me? There were plainly websites which were not linked to bricks and mortar retailers. In fact, as I understand it, Deckers itself offloaded out-of-season stock through those unlinked websites. Do we know why Hoka wanted to know who all those unlinked websites were, and what was the purpose, from Hoka's point of view, of wanting to have Deckers? What was the purpose, from Deckers' point of view, of wanting to have some control over the unlinked websites and how the stock was sold through the unlinked websites?
And also, what specific findings of fact did the CAT make about this? Because there are a number of paragraphs, they're not always entirely consistent as to what it is making as a finding of fact.
Yes. My lord, can I come back to that when I go through the judgment? But can I just give you a headline response now? So and it may not be a complete response, but it's very important in my submission to distinguish between websites that were not part of the selective distribution channel, what the tribunal calls the main retail channel, but were part of the clearance channel. And as my Lord Justice Snowden just put to me, Deckers itself, when it has in its factory lots of old stock, it itself sells in the clearance channel. And what this clause is talking about...
And just pause on this. I mean, there is a finding, I think, that I'm aware of, or at least appears to be a finding, that Deckers wanted to control the sales through that clearance channel. And I'm trying to understand what control and why.
My Lord, yes, and actually as a matter of fact, there's a finding, well, at least there was evidence before the tribunal, that Deckers is moving to, in a sense, be the only... what we're talking about here is old season stock in Deckers' factory. So not that retailers are hanging on to, but in Deckers' factory.
Yeah, understand that exactly.
And there was evidence before the tribunal that Deckers is moving to, in fact, take total control of that, so sell all of that directly itself. And there's nothing wrong with that in my submission, because it's easy to see, having set up a selective distribution system, which is all about the brand and the new stock and so on, it's easy to see why it would be inconsistent with that to allow large quantities of old stock to be combined with the new stock in terms of brand image. And so... And one can see, for example, but let me come to this in more detail when I come to
I'm not sure I followed what you just said to me. By definition, the clearance channel, in other words, we're talking about the non-retailer linked websites. By retailer, I mean bricks and mortar retailers.
My Lord, no, not quite, because this is talking about the selective distribution system, which is the main retail channel. So it's saying, if you're in our main retail channel and you want to sell through a website, then you need to have a name that's similar to the store, which is linked to the store.
Yeah, absolutely. But we know that Deckers is selling its manufactured surplus stock, old stock in the factory, as you put it, through authorised online outlets, or online sites
that specialise in clearance sales,
that have no links to any bricks and mortar.
Correct.
And there is a finding made by the CAT, and I'm not sure how far it goes, that Deckers wanted to have control of that online clearance process.
Yes.
And I'm not sure what control it wanted or why, because the one thing that I think the CAT found is that it didn't, or the effect anyway, using that word neutrally, of what it did was to stop up and running, accessing that clearance channel, as the CAT called it. And I'm at the moment not understanding what control Deckers wanted over that clearance channel and why it wouldn't allow up and running to access it through an unlinked website.
This is paragraph 133.
It's 133.
Can I, if it's okay, can I address it when I come to those paragraphs in the judgment? Because I think otherwise I'm at risk of giving you a half-baked answer. So if I could just carry on with framing the appeal. The question the rhetorical question that I was going to ask is, what is it that led the tribunal to the conclusion that this clause, which we say obviously doesn't affect competition in any serious way in the market, what led the tribunal to the conclusion it was anti-competitive? Well, it really comes back, I think, to the point you just put to me, which is that the key misstep was that the tribunal, having found as a fact that Deckers enforced the provision on this occasion against up and running in order to prevent it entering the discount-only channel, the tribunal then wrongly characterised that as a matter of law as resale price maintenance, which is a hardcore restriction. And so I'm taking the finding of fact that you just put to me in paragraph 133, and I'm saying that the characterisation of that by the tribunal as resale price maintenance, as RPM, is wrong, because resale price maintenance is vertical price fixing, where a supplier determines that a retailer must sell at or not below a specified price. It's not any vertical measure that has the effect of softening or reducing price competition in relation to the brand in question. And that's an important distinction. I'm going to come back to that. And in this case, there was no RPM for the reasons canvassed a moment ago in discussion with Lord Justice Green. There was no finding by the tribunal that hawker retailers were required to sell at or above any particular price.
There was no finding, certainly in relation to hawker retailers. If by retailers you mean bricks and mortar retailers or bricks and mortar retailers through their linked websites.
Correct.
That I understand. What finding was there about whether there was any price maintenance or price restrictions in the clearance channel?
No finding.
Because, well, what did the CAT mean when it said that Deckers wanted more control over the sales through the clearance channel?
My lord,
there was just a suspicion,
yes,
and a moment I can't ground it in anything, and I need help on it.
Yes.
That Deckers was in effect trying to ensure that the sales through the clearance channel took place above a certain level, and that they didn't want up and running going into the clearance channel and undercutting the people selling through the clearance channel.
My lord,
I may be completely wrong about that, and there may be no basis for that at all, but that's the only thing I've come up with in my own mind at the moment as a question that I need an answer on.
My lord, in relation to that question, the first point I would wish to make is that there is no finding by the tribunal of any requirement that pricing in the discount channel is at or above any particular level. So there's no finding of the tribunal in relation to that. Now, you've asked me a second question, which is what's meant by control. That's the point that I want to defer and come back to.
Okay.
But the third point that I would wish to make about this is that, let me just summarise why the tribunal got this wrong, where it was going with this. Tribunal said, right, no restriction on pricing, but Up and Running's own incentives, so their own commercial incentives, were not to discount heavily on the main channel. So the purpose...
Yes, because they didn't want
to
a
cannibalise
linked
their
website cannibalising their retail output.
Exactly.
But there would have been, in a sense, nothing to stop them, no damage to them, if they were selling at reduced prices through an unlinked website, because that wouldn't... There's no connection, there's no visible connection.
Correct.
It doesn't undermine.
Correct, and that's what the tribunal got obsessed with, if I could say that without any disrespect, but that is not...
There is a danger I'm doing the same, I suspect.
Well, my lord, certainly not intending to disrespect you. The problem with that is that in any selective distribution system where it's set up in order for retailers to invest in in brand, and often there are technical requirements, involves a lot of investment by the retailer themselves. There's a risk if the distribution system is not kept fairly watertight of free riding through other channels on that investment. So that's always a risk in a selective distribution system, and it will almost always be the case that a retailer in a selective distribution system will not have an incentive to price really low to cannibalise its own sales. But that commercial pressure, its own commercial incentives are not RPM. So in a sense, the tribunal's reasoning proves far too much, because if the tribunal were right that not letting someone exit a selective distribution system to undercut is RPM because their own commercial incentives mean that they won't discount heavily in the main channel, that would mean almost every selective distribution system is a restriction of competition by object. And so that's really the nutshell answer to my lord's point, but I will deal particularly with the factual point.
Does it boil down to that? I mean, I'm just checking the paragraph. So 133, 139 and 142 to 145, I think, pull together the CAT's findings on purpose. 133 and 139 don't refer to price, but then 142 to 145 do refer to price, but they explain how limited the impact on price was. There was only surplus stock, only up and running, and only anonymized websites. And your point is that technically this isn't RPM. At most, you put it, it's a softening of price competition.
Of intra-brand.
Intra-brand, we get all that. That comes back to the whole question of what's meant by economic context. But it's intra-brand only, and it's a softening. It's not formal RPM as that term is understood.
Yeah.
But that's if we take the CAT's findings, as gospel, as it were.
Yes. Yes, I mean, I'm happy to take the facts. I mean, there are some interpretations of findings which I'll come to, but I'm not in the business on this appeal of trying to overturn facts.
No.
But can I just on the paragraphs that you were just putting to me? So, paragraph 133. Let's look at that. Page 184.
Yeah.
The real reason for the refusal of permission was to protect the selective distribution model for the main retail channel.
Yeah.
But that's classic. That's what a selective distribution system does. It does. You'll see this in the cases. I'll show you. That's the whole point of one.
We get that.
And then if we go to 167, can I show you that? So this is under the legal analysis, page 211.
Sorry, can you just give me the page? Trouble like this CAT
184.
Sorry, trouble with this CAT judgment, like all other ones, is you have paragraphs that spread over page after page after
and they go backwards and forwards.
But I'm just trying to find 133. There it is.
184.
I'm trying to find 133 again.
On page 184, my lord.
Yeah, thank you. So, yeah, you focused on the first bit of the second sentence of 133, the real reason, and then it says, and in particular,
yes,
to prevent the establishment of a new clearance website in the clearance channel, over which Deckers would have less control than it had over the specialist retailers it had appointed in the channel, meaning, I think, the clearance channel. So, in other words, those two bits of that sentence are dealing with different things. The first is to protect the selective distribution model for the main retail channel, which is dealing with basically don't cannibalize your bricks and mortar retailers or their linked websites. But the second bit is saying it wanted also, although it says in particular, it says it wanted to have control. It was worried that it would have less control over a new clearance website, i.e. visibly unlinked to the bricks and mortar retailer, than it had over the specialist retailers it had appointed in that channel. So as I understand it, Deckers goes to a specialist online retailer only, dealing in discounted stock, and says, we will supply you with our factory surplus for you to sell through your specialist online clearance website. And the CAT is saying Deckers didn't want up and running getting into that area because it couldn't control them. Well, what control was it after, other than controlling the price?
Well, my lord, the first point I'd make in response to your observation is that in our submission, those two parts of that sentence are a corollary of one another. And so if you are protecting the selective distribution system, the way you protect it is to prevent your retailers from selling through other channels. That's what's meant by protecting the selective distribution system.
But why when it's not visible to the public? I mean, why when you've already got visibly unlinked, appointed clearance channel websites selling at discounted prices, does it matter two hoots that you've got another online retailer not visibly linked to any of the main retail channel doing exactly the same?
Well, my
who
lord,
cares? It's just another cheap way of getting out of season hawker
Well, my lord, let me show you in the supplemental bundle. Can I just show you this? So if we go to...
I will just say, my lord took you to a number of other paragraphs.
I'm going to come back to you. I won't. Don't let me forget, because I want to go to paragraph 167. So, but let me just deal with this point. So, if we go to supplemental bundle, please, tab 16. This is the evidence of Mr. Hager. So I just want to show you 2 or 3 excerpts from the evidence before the trial, because it's just to show you why why there would be an incentive for deckers to keep the 2 channels separate, if I put it that way, which I think is the point being put to me. So if you go to page 143...
No, actually, I fully no. I mean, that's not the point. I perfectly understand why deckers wanted to keep the 2 separate. That I completely understand. But in a sense, because
control is the control point.
It's control.
That's a different point.
Yes. Okay. I'm
mean,
sorry.
If you add up the words "less control" with 142 to 145, the implication read in the round is the control was over extreme forms of discounting through anonymised websites. I'm not saying that's right or wrong. I'm just saying that's what the CAT, I think, found.
I think that's where they were going with it. I agree with you both. But let me just show you some of the evidence. If we go to page 143 in the supplemental bundle. So Sport Pursuit is the only retailer we've worked with in the UK that specialises in discounted products. So apart from Deckers itself, that's the only retailer in the clearance channel. But I can't think of a retailer, so this is a retailer in the main channel, that doesn't discount on their website or bricks and mortar store at some point in a season. Sometimes retailers will buy discounted end-of-season products from us and display them in their stores or on their websites, including Up and Running in the past, both in their bricks and mortar stores and on upandrunning.co.uk. Now, that's that. So if you go...
Okay, but just pausing there.
Yes.
In a sense, there's always going to be some inherent restraint against deep discounting when you've got a bricks and mortar retailer with a linked website.
Yes.
Because the cannibalization point, they're never going to massively undercut their stores, because that would be commercial suicide, because everybody would just go and try the stuff on in the stores and then buy them online.
Yes.
Right? Because that's what people want to do, because you want to know the shoes fit you, your running style, your feet, everything else. But when you've just got a non-linked website, a discount website, there is no inherent limitation on how much discounting that person will want to do. In fact, quite the reverse, because they don't care about any bricks and mortar stores. They'll sell them for whatever they think they'll sell most shoes at to make a profit.
My lord, correct. Now, just 2 important points to keep in mind, and I know that you definitely have the first of these points, which is that when we're talking about discounting in the clearance channel, we're not talking about current season stock. We're talking about old stock.
It's how I get my shoes.
Right. So most of the retailers are going to have only a limited amount of that, because they know what they can sell. And so when we're looking here at paragraph 70, that's no doubt why Mr. Hager's saying sometimes retailers will sell discounted out-of-season stock on their website, even buy some more from us. And so there's generally not going to be a glut by retailers of out-of-season stock. Now, the reason why there was in this case was because of COVID. That was why. And I pray that in aid, because if ever there was a niche issue, this was it. And the second point that I want to make, which I'm not sure you have yet seen, is that the evidence before the tribunal was that no other retailers in the main channel had even asked to enter the clearance channel. So there wasn't any demand for it. And that's a really important point when it comes to whether or not there is an overt restriction of competition. So I wanted to show you, I've shown you paragraph 70. Can I show you paragraph 80 on page 146? So Up and Running sometimes sold Hocker at a discount on their website at their discretion, been shown examples of this of up and running selling brands, including Hocker, at a discount. In the past, they've brought clearance Hocker product, which they sold at a discount. But I don't recall the details as to the volume or frequency of these products. That's in line with paragraph 70. And then can I just show you part of the cross-examination of Mr. Hager at trial? So this is tab 23.
And just pausing there, so that 80 is dealing with up and running selling discounted at a discounted price on their own website.
Yes.
So, in a way that would either allow them to clear stuff that's left in their stores, or not in a way which would undercut their, would undermine, cannibalise their own stores.
Well, that was up to them.
Yeah, exactly.
Up to them, but yes, exactly.
There's an inherent sort of...
That's what it's referring to.
Business restraint. So it's just talking about a linked website.
Yes, it's talking about a linked website. And the point there being that they have sold at a discount, and they have actually gone to Deckers and bought more out of season stock and sold it on their linked website. Now, going to the cross-examination, please, behind tab 23, page 437.
437.
So tab 23, page 437, and you can see Mr. Tiswell, the chair of the tribunal, himself asking questions of Mr. Hager. And then he says, if you go to line 18, this is the answer. As a specialist clearance retailer, the way that they will work, so this is, you can look at line 11, it's Sports Pursuit, which is the only retailer that Deckers has worked with for clearance of old stock. As a specialist clearance retailer, the way they work is they will buy excess stock when we have it, and we will do flash sales with them for a period. They reserve bulk product, they sell it on their site, we then ship it to them, and they ship directly to consumers. So we do short bursts with them. And so one can see there, I can't give evidence from the bar, but when it's talking about flash sales and short bursts, you can easily see, as a matter of logic, why the timing of that might be important, why you might not want to time that with the release of a new product. And so that may be a reason why Deckers wanted to retain control of the way in which that old stock was released in bulk. But the tribunal didn't make any findings as to that, but didn't consider whether that was the objective. They just, as I say, were obsessed with this point about price. Now,
so just to make sure I've understood that point, you're saying that at this, that Deckers wouldn't want, as it were, this season's colour running shoes are just about to be launched, to be prejudiced by the sale of last season's colour through at discounted prices through clearance websites. The two shouldn't. It's a timing question. You're saying, not necessarily a price question.
Well, that's certainly, we can draw that from that evidence, I would suggest. And one can see as a matter of logic that if one has slightly changed the colour for the new season and is selling it...
I'm not sure you quite get it out of that Q&A, but I can see the point you're making.
Yes, and my point is that the tribunal just didn't ask itself those questions. As I say, it got rather obsessed with this point about price, and it ran with it. And it didn't ask itself whether or not this mattered. It didn't ask itself...
I mean, that's a somewhat different question. I mean, essentially, your starting point could be that you accept the findings in 142 to 144, in which there is an acceptance by the CAT that Deckers did not apply any form of price control to anybody else.
Yes.
That it was only applied to discipline up and running, only to prevent it from entering the clearance channel, and thus pricing Hocker at lower levels it wished to, in the same way that Deckers and others in the clearance channel were doing at the time. I mean, you can simply just draw a boundary around the facts found by the CAT.
I can.
And without really having to challenge them, particularly rely on 143.
Yes.
And just simply, and then the inference in 144 that the CAT says that direct interference with A, not the networks, a retailer's pricing typically amounts to an obvious infringement.
My lord, that's the primary way.
So your easiest starting point is simply to define what the CAT actually found and did not find.
My lord, yes, exactly. And so
the reference to COVID is paragraph 6. I mean, there's no finding that this was a general policy. This is a one-off relating to the fact that Up and Running had the COVID stock, and for understandable reasons it wished to dispose of them.
My lord, yes, that's the primary way in which I put my case. I say that 143 and 144 are very important because they show that there was no restriction placed by Deckers on the retailers as to their pricing.
Yeah, it's not formal RPM. It is a form of interference in price.
Well, my lord, I say there's no interference with price, and there's no interference with price in the same way.
Well, if you accept the findings of fact, they are that the reason for the termination was to prevent a level of discounting which Deckers thought was going to be undesirable. That's about as high as the CAT's findings go. Now you can call it RPM or some looser, softer form of effect on price. There is an effect on price.
There may be an effect on price, but what we say...
I agree. Then there's a whole question of economic effect.
Yes, exactly.
But just defining the facts as found...
Yes.
This is the high... When one's trying to add up what were the facts as found, because in paragraph 133, 139 don't really get into... They're all about control.
Yes.
But then in 142 to 144, you get the reference to price as really why the control was required. But, I mean, the starting point is simply just add up what they found and what they didn't find, and then ask yourself the question, was the conclusion, from their finding of fact, which went into their conclusion of law, was that correct?
My lord, I agree. I hold firm on this not being RPM because that's important for the vertical block exemption.
Yes.
So we say I'll come back to that.
We get that. The VBE is a different issue.
We'll come back.
We've got to look at the terminology and see what was meant and how it defined price control and so on and so forth.
But leaving that aside,
yes,
then I do say that taking these findings of fact at their highest,
yes,
that this is just nowhere near the kind of obvious effect on competition in the market that one is looking for an objective restriction.
I think I understand the way you put that, and you say that in a sense trumps all this analysis.
Yes.
Whatever. But just while we make sure we've added the right paragraphs to our list of findings of fact. I mean, 147 is where it ends up, isn't it? Which, as I read it, was definitely a finding about pricing.
147. So
we find that Deckers was, at least in material part, employing a strategy of using what appeared to be a legitimate reason to cease to supply Up and Running in order to prevent entry into the clearance channel and thus, 1, interfere with the levels at which Up and Running was pricing Hoka products on the running shoes website. That's the unlinked website in the clearance channel, which he wanted to get to the clearance channel, and preventing discounting of Hoka product on that website, i.e. in the clearance channel.
Yeah.
So that seems to be a finding that Deckers was concerned that if Up and Running was allowed into the clearance channel, where, as you just pointed out, there only was one other approved, or it seemed to be Sports Pursuit was the only approved seller in the clearance channel, that Up and Running would undercut them.
Well,
how else am I supposed to read that?
Undercut Sport Pursuit.
Yeah.
Well, whoever
was in the clearance channel.
Sorry, and you get that, my lord, from which subparagraph in particular?
Well, interfere with the levels at which Up and Running was pricing Hoka on the running shoes website. That's in the clearance channel, preventing discounting of Hoka product on that website. Well, why would they be bothered if Up and Running was selling Hoka product in the clearance channel at more than Sport Pursuit was selling it? Why would they care? It only could have mattered to them if Up and Running was going to go into the clearance channel and undercut their, quote, authorised clearance channel retailer, sports pursuit.
Well, my lord,
why would they care?
Subject to the point about, can I just show you 167, because page 211. So subject to the point about timing and so on, which is actually reflected here at 167.
Yeah, timing is one that you've introduced.
Timing and volumes.
Okay, but that's not what 147 is talking
about.
No,
but this is now in the section. It's true. I mean, I have struggled a bit with the judgment because there are inconsistencies in it. But paragraph 167 is where they've set out the purpose of the contractual provision for the purposes of the object analysis. And you can see in the main part of the paragraph that the general purpose is said to be to promote the selective distribution model by preventing the emergence of competing business models or channels for distribution. Pausing there, we say, well, that's completely fine. That's what selective distribution systems do. And then it says, the discretion and vague wording enabled Deckers to pursue two discernible sub-purposes which emerge from its brand strategy and from the evidence about the way in which Clause 15 has been applied. Now, pausing here for a moment, the only evidence about which it had been applied on which was this one instance of enforcement. So it's very narrow evidence that the CAT is looking at. But then at 1, to restrict entry into the clearance channel, being the additional channel for the online clearance of residual stock, so that Deckers is largely able to determine when and at what volumes are sold through this channel. And that does, in my submission, provide support for the point I was making on the basis of the evidence.
Yeah. There's no finding anywhere is a purpose or even the effect of what they were doing was to undercut sport pursuit.
Absolutely no finding of that. So,
as I say, there isn't certainly. I have not seen an express finding. I say 147 is the one where it deals with price, and 167, as you point out, it deals with when and where, or when and how much, what volume.
My lord, yes, and really all of this. Can I just step back and place this in a sort of bigger, in a wider frame, a bigger picture point? Is that this is all about what the tribunal is here looking at, what the aim of the clause is, and they're ascertaining the aim largely by reference to this single instance of enforcement. But really, when one is looking for an object restriction, the aim, as in the subjective...
But that's why 143 is important. I mean, that's why it does seem the easiest starting point for all of this is simply to add up what they found. What they did find was this was limited to one retailer, one circumstance in relation to one block of stock.
Exactly.
In relation to one form of online website.
My lord, exactly. And that could not be a more niche issue. It could not be more niche. And really, what the tribunal's doing here is a kind of competition law by numbers approach, if I can say that without being too disrespectful. And you end up with a conclusion which is completely counterintuitive in relation to a niche, time-limited point. Yeah. And the tribunal just failed to look, having gone to the effort of looking at the expert evidence and determining market shares, failed to put that into its analysis at all. There was evidence before the tribunal that not a single one of the other then 93 retailers had ever asked to have a website with a different name, had ever asked to enter the clearance channel. There was no demand for it. It's obviously an important thing, because if there is no demand for that in the first place, then that tells you something, that this is a niche issue limited to a one-off occurrence, which was COVID, and the tribunal lost sight of that. Now, I'm going to...
Although, I mean, you say this is, a particular instance responding to a post-COVID glut, but I mean, there are some slightly more general principles at stake in the round.
There are.
But I think your point is that this analysis doesn't touch those.
It doesn't touch on it.
Yeah. Okay. Sorry, I should say. I mean, I've been pushing you quite hard, and I apologise for interrupting so much. But it's just, and I haven't been asking the questions because I've got any intent or purpose behind it. It's really just trying to understand, before we launch into what I suspect you're about to launch into, which is the law.
Yes.
What we're actually dealing with in terms of fact.
My lord, I'd much rather get questions, so there's absolutely no need to apologise. I hope that I've
Or within restriction, within the...
I think we've got the luxury of sufficient time for this appeal. So can I deal with the law now? Can I start with the Ping decision of this court in its authorities bundle 1, tab 11, starts at page 376. This was a case concerning a selective distribution system, and the case related to the sale of golf clubs by Ping, which was a major manufacturer. And Ping had an absolute ban on internet sales, so it was a complete ban. And
we're looking forward to going through the cases, but
yes,
to encapsulate the issue,
of course,
as we understand it, you say that the CAT erred because it either equated or elided an analysis of legal and economic context with purpose.
Exactly.
So there are 4 components to the test, you say, according to the case law: content, object or purpose, legal context, and economic context. And you say in paragraphs 44 and 167 and others, the tribunal simply treated an analysis of purpose as answering all the other questions, and therefore it ignored economic context, which requires at least some analysis of interbrand competition, position in the market, degrees of switchability, and so on and so forth.
My Lord, yes, there are really 2 points on object. So if I can just respond by saying, cutting to the chase, what are our 2 points? The first and important point is that when the tribunal came to analyse whether or not these clauses had an anti-competitive object, there is nothing in the section about the economic context, nothing about the small market shares of the parties, nothing about the nature of interbrand competition. Who are the other players? Is this strong competition? Nothing about whether there was any demand from other selective distribution retailers for websites with names not associated with their physical stores. I said there was evidence that there was no such demand. Nothing about whether this was a one-off because of COVID, so no real consideration of that. So, in other words, the question whether was this clause likely to have any impact on competition in the market, as opposed to effect on this particular retailer, was not addressed. So that's the first point. Second point is that what the tribunal, as you've said, my lord, did address in this section was whether the clause had a legitimate aim. And we can go later in due course to some of the other paragraphs, but all of the section on that it's headed legal and economic context, all of that section is about whether or not this clause had a legitimate aim. And it focused solely on that question, and that's inconsistent with carte bancaire and with the case law. And so, really, the fact that one of many, I think there are 93 hawker retailers, had excess stock as a result of special circumstances, and this clause was enforced against that retailer on that occasion, just does not come close to answering the question whether this clause is so obviously harmful to competition in the market that it infringes competition by object. That's what we say about effectively grounds 1 and 2. So, my lord, should we turn to the law? So Ping. So I was saying it was a complete ban on internet sales. So Ping insisted that if you want a Ping golf club, you have to come into a store and be measured and get technical advice, etc. And it is established in the case law that a complete ban on internet sales is an object restriction. Indeed, it's one of the rare examples of an object infringement in a vertical context. And the case is helpful for present purposes because it sets out the analytical framework that must be applied when determining whether a provision of a selective distribution system infringes competition law by object. And if we could pick it up on page 381, let me just show you first of all, at the very bottom of the page, in fact it's the top of page 382, you see the clause. We have decided to issue a new policy which will not allow account holders to execute sales transactions with consumers on the internet. So a complete ban on internet sales. Now I'm going to skip forward and then come back. So if we go to page 393, I just want to show you on page 393, just under the heading the CAT's judgment, you can see the CAT had a three-stage or three-prong scheme for considering the CMA's decision. And so the CAT set out the questions to be addressed in 3 stages. Does the internet sales policy satisfy the criteria in the Metro case and so fall outside Article 1011? 2, if not, does the restriction reveal a sufficient degree of harm to competition to be considered a restriction by object within Article 101? And if it is restrictive of competition by object, can it nevertheless be exempted under 1013? I'm pausing here, an important point, and a point which the CAT got right at the outset of its judgment, but I'm going to show you then misapplied. The important point is that the Metro case is about legitimate aim and whether selective distribution restrictions are proportionate to a legitimate aim, and that provides a means by which a selective distribution system can fall outside Article 101. But you can fail Metro, for example, because the criteria are not set out with sufficient transparency or clarity, etc., and still not be an object restriction. And that's the point the CAT was making, and the Court of Appeal agreed with that. And I'm going to show you...
a safe harbour. It's described as a safe harbour.
Yes.
If you're outside the safe harbour, you just go back into the ordinary analysis.
Exactly.
And Mr. Khan suggests that if you fail the safe harbour, then that's a fairly strong indication of restriction, but that's...
We say it's wrong. And you can see why it's important that it is wrong, because there may be all sorts of businesses with selective distribution systems who are facing plenty of inter-brand competition, who don't bureaucratically set out all of their requirements in a way that a court would, or a competition authority. That commercial enterprises may be a little bit fuzzy about those things. And so you may fail Metro, but actually this may not have any impact on competition at all. And it's really important that competition authorities and courts don't get drawn in to that bureaucratic exercise of working out whether the clauses are set out sufficiently clearly. And no doubt that's why the CMA has intervened in this case, effectively in our favour, to say it's really important to consider whether or not there's a restriction of competition by object. Now, so that's the 3-stage framework. Now, on appeal, Ping, just like Hocker in the present case, did not appeal the finding that the Metro criteria were not satisfied. So the appeal in Ping focused on the finding that the ban on internet sales infringed competition by object. And then if we go back, please, to page 383, we can see the Court of Appeal's exposition of the law, and it follows the tribunal's 3-stage approach, but in a slightly different order, and it does jump about a little bit, but it still sticks to these 3 different stages. And can I just ask the court, just read to yourselves paragraph 23 at the bottom of the page, please. And you'll be familiar with this. And can I just ask you to go on and read paragraph 24, and then I'll make a couple of submissions about paragraph 24. So the court's here recognising that vertical agreements raise different issues to horizontal agreements when it comes to competition law, and that vertical restrictions are often good for competition, and that can be the case with selective distribution systems, which is why the Metro line of cases developed. And here the court takes us to Metro. And just note 2 points. So the first is, I'm looking by letter D, where a selective distribution network is appropriate because of the nature of the goods, even though restricting sales to certain outlets might reduce price competition to some extent, it was justified because it enhances competition by other means. And so that's really directly on point here. So this is a case, the finding of fact that I'm squaring up to, made by the tribunal, is a finding that you can't use a particular outlet. And yes, that might have some impact on reducing price competition. But generally, that is generally not problematic if there's no market power. And Metro finds that if the Metro criteria are established, then it's not problematic, in fact. And then...
I don't get the link with market power in that paragraph.
No, you're right.
So it talks about that if you restrict the sales to certain outlets, it might reduce price competition to some extent. It was justified because it enhances competition by other means.
Yes.
I'm not sure what the other means are.
Well, the other means, my lord, so you're right, first of all, that this does not refer to market power, so that's correct. The other means are that having a selective distribution system which can place requirements as to the way the brand is presented, perhaps technical requirements, encourage retailers to invest in the brand, are all legitimate and healthy ways through which brands compete with each other. And what Metro is saying is, and the second point I wanted to make is that Metro does require, so the thing I was criticising the tribunal for a moment ago, which is focusing only on legitimate aim and proportionality to that aim, that is part of the Metro test. So Metro does require an analysis of whether the selective distribution system is justified as being proportionate to a legitimate aim. But that isn't the approach, isn't the sole question that one is asking under the object analysis.
It's not a live issue in this appeal whether the Metro doctrine applies. It's accepted that this falls outside of Metro.
Correct.
So the question is, what is the legal effect of falling outside of Metro?
Exactly.
Which you simply say you go back into the ordinary rules and you apply the 4-stage test.
Exactly right, my lord, yes.
So just for me, the other means by which competition may be enhanced in the type of scenario that we're looking at here, it's got nothing to do with market power. It's you will enhance competition between luxury brands by introducing another player in the luxury brand market. Is that right?
Yes, it's the way in which. So Hocker, we can see some of the findings of fact.
I'm going to stick with Ping for a second.
Yes. Yes.
Essentially, Ping say, look, to play decent golf without golf clubs, you actually need to have some that are measured and fit you, which I understand. And therefore, the restriction will mean that you don't get discounted Ping golf clubs, but you get another player in the luxury fitted golf club market. So you increase competition in a particular space, even though you're not reducing.
Yes, because price is not the only parameter of competition. Of course, there are quality parameters of competition, for example, and technical parameters of competition. And really, to compete on quality, you may really want your retailers in the selective distribution system to invest in having someone there to fit the golfer with the club.
Yep.
That all requires the retailer to invest. And so if you then allow other people, or indeed the members of the selective distribution system, to sell outside that channel and discount heavily, you're allowing free riding and undercutting the investment made, which you're trying to encourage.
Yeah.
But the point being made in 24 is that you can have restrictions on intra-brand competition, which actually enhance, ultimately, inter-brand competition.
Exactly. That's exactly the point.
Which is where you came into this argument today.
Yes, exactly.
And if you go back to cases like AEG, going back 40 plus years ago, I think the only two people in this room old enough to think of that as current is myself and Mr. Khan. But that was when the court accepted that some restrictions on price, which are inherent in the selective distribution network, may actually be neutral or pro-competitive.
That's right. And then, of course, where you've got healthy inter-brand competition, then you would expect that any restriction of price, that prices will be disciplined by the inter-brand competition.
Yep.
And so there is a sort of disciplining force from the other brands. Yep. And that's why, you're right, my lord, that market power is not referred to here, but that's why it's important when it comes to the vertical block exemption, which proceeds on the basis that unless there's market power, you don't need to get into why was the clause enforced, you just look at what the clause says, and there's a safe harbour for anyone that's under 30% market share, save for these an agreement which contains hardcore restrictions.
Okay, and you were about to, and I stopped you, but you should now do it. I mean, can you draw the parallel between the sort of luxury ping golf club and the need to have it fitted with the Hoka shoes?
Well, I don't need to do that, is my point, because so the Metro test does require an analysis of the luxury nature of the brand, whether or not the restriction is proportionate to protecting the brand. But the object test doesn't require that kind of analysis. So I don't need to go there, and the block exemption doesn't require that kind of analysis either. So this is a specific Metro type of analysis. And you see at 25 that some restrictions have to be imposed on retailers in order for selective distribution networks to work. And you can see, again, a reference to the Metro criteria, and then this: restrictions that are necessary to maintain that network won't constitute restrictions on competition, will fall outside 1011. In particular, a prohibition on authorised retailers selling the goods to retailers outside the network is regarded as a corollary of the principal obligation. Other restrictions, for example, may well be permissible, and so or may not be and have to be exempt. But that's all about Metro, and it's recognising the whole raison d'etre of Metro, which, as I said, we're not relying on, Ping wasn't relying on in the appeal, it did at first instance, is that selective distribution systems are generally pro-competitive, even if they restrict some intra-brand competition. You then have a reference to the block exemption at paragraph 26. And then paragraph 27 refers to the hardcore restrictions. I'm going to come back to the block exemption in more detail. And then if we can go over the page to paragraph 29, you see that to say that a restriction is a hardcore restriction is not the same as saying it's a restriction by object for the purposes of Article 101. So it's not the same thing. And then the court, you can see from the heading in the middle of the page, dives into the object analysis in more detail. And you can see that from paragraph 30, the leading authority, as the court will be aware, on object restrictions is the Carte Bancaire case in the Court of Justice. And the court goes through that judgment, starting with the Advocate General. So you can see at paragraph 32 a reference to Advocate General Ball's opinion. And he explains, in his opinion, he explains the concept of what's meant by a restriction of competition by object. And if you go to page 386, by letter C, however, he said that such advantages, so these are the advantages of having a sort of object box, if I can put it that way, which are of procedural economy and legal certainty. Such advantages materialise only if recourse to the concept of restriction by object is clearly defined, failing which this could encompass conduct whose harmful effects on competition are not clearly established. And then 33, he described the importance of analysing the object of the agreement in the economic context in which it operates, but also of clearly distinguishing that exercise from the examination of the actual or potential effects of the conduct of the undertakings concerned. So there's a distinction between looking at the economic context for the object exercise and a full-blown effects analysis with all of the economic evidence that one sees in these cases. He gave as one example of relevant economic context a situation where the parties to the agreement held only a tiny share of the relevant market, a consideration of context could either reinforce or neutralise the examination of the actual terms of the purported restrictive agreement. So that's an example he draws out as being an obvious example of a piece of context that may well be relevant. And of course, we emphasise that point. And then we see him, we can see at 36, the Advocate General structured his analysis of the restrictions in 3 parts: an examination of the content of the measures, an examination of the objective of the measures, and an examination of the context of the measures. And his conclusion was that the restrictions in the agreement were not object restrictions. And then the CJU arrived at the same conclusion as the Advocate General and applied that 3-stage analysis. So looking at the content and the objective and the economic context of the measures. And then the Court of Appeal set out the key parts of the court's judgment. And I think if we could take them from here, I will go back to the carte bancaire judgment, but I can do it really briefly if we just look at the relevant passages here. Could I just ask you to read over the page from letter B down to letter H to yourselves?
Sorry, I messed the page up.
So
Which page are we looking at?
387, my lord. 387. It's setting out the key parts of the court's reasoning in carte bancaire.
Paragraph 53, which is the paragraph, I think, which is cited most commonly in other cases. It's maybe debatable whether it's 3 or 4 parts, because legal in economic context can be, legal economic context, as in generics, can be whether there are patents, regulatory regimes. Economic context is a much more classical analysis of market structure.
My lord, yes.
Interbrand competition in particular.
My lord, I'd agree with that.
And
thank you. It's helpful.
Speaking for myself, I think there is the economic context analysis becomes blurry, or it begins to blur into the effect. And how, I mean, I think it's a point that we saw on the previous page, that the Advocate General at paragraph 34 is recorded as sort of effectively acknowledging that the courts have blurred that distinction between the factors relevant to an examination of the anti-competitive object and an effects-based analysis on the other. How do you reconcile the two? I mean, how far do you go in looking at economic context without straying into an effect?
I mean, that's a very fair question, and there is some element of blurring because you are looking at the economic features of the market. And the court will be aware, having seen lots of competition cases, that where a competition authority or indeed a claimant carries out an effects analysis, so it seeks to show that an agreement has in fact had an anti-competitive effect, one normally sees really quite detailed and nuanced economist heavy analysis, regression analyses of actual impact. And I'm not suggesting, and it's not the case, it's the Advocate General's quite right to say you don't do that.
So is this really just a sort of threshold test? I mean, you can just knock it out if it's obvious just on the face of everything that the potential effect, and I'll use the word effect, but the economic context is just so obviously, it's just so obviously tiny that you don't even need to have economists running around.
You can certainly do that.
Well, the other way around, it is, as in generics, when you've got a dominant incumbent and very large international entrants.
Yes.
When the court just took as read that these were enormous companies entering a market with entry barriers, with a dominant incumbent trying to impact upon generic price competition.
My lord, exactly so. And
but that's one end of the spectrum.
One end of the spectrum. So take generics, take where the court said, well, the context of this is, as you say, you've got patents, which the normal process of competition requires those to be challenged if they look potentially invalid, and this is buying off market entry, and market entry would lead to prices of these drugs tumbling. And so that's relevant context at one end of the spectrum. Another example of that is the Super League case, where you've got UEFA and FIFA, who are saying to
control
clubs,
entrance of new competitions across the world.
Exactly. They're shutting out any potential competitor leagues. Yeah. And so you don't have to look at economic context very far at that end of the spectrum. But at our end of the spectrum, we say at a minimum, you have to be asking yourself, well, what are the market shares? I mean, we know that from the vertical block exemption. That's really critical. What are the market shares of these parties? What are the circumstances? I mean, the tribunal looked at this one instance of enforcement and drew from that conclusions about the clause itself. Now,
we understand. I mean, compare that with Ping. Ping, I think, had 30% of the market.
Yes.
And it applied to something like 1,200 distributors, retailers were subject to the same policy. It covered the entirety of the country, every retailer, and about 30% of the market.
And you can see why a complete ban on internet sales in those circumstances makes a difference, because if you can't sell on the internet at all, then you're limiting your sales, you're partitioning the market geographically. So a golfer in Newcastle has to go to the Newcastle shop. They can't shop around and see that Ping golf clubs are being sold more cheaply in Southampton. So so not only were Ping's market shares large, but the nature of the restriction was such that it had a much more obvious impact on competition. Going back to the judgment, you can see on page 388 that the court referred to the vertical block exemption and the vertical guidelines. I'm going to come back to those, so I don't think we need to dwell too much on what the court says. You can see over the page, on page 389, that the court refers to two cases concerning restrictions on online sales. The first is the Pierre Fabre judgment of the Court of Justice, which predated carte bancaire. And again, like Ping, that was a complete ban on internet sales. And the second was the Coty judgment. Can I just show you? I'm going to come back to Coty in the context of the vertical block exemption, the Coty judgment itself. But if you look at page 390 in this report, in the bundle, paragraph 49, you can see the basic facts of Coty. So those were luxury cosmetics. And internet sales, this is by letter E, were permitted, but were limited to sales through an electronic shop window of the authorised store. So a provision reasonably similar to the present. So it was a shop window of the authorised bricks and mortar store, and also subject to the requirement that the website reflect the luxury character of the products. Therefore, the contract prohibited the use by dealers of third-party internet sales, such as Amazon. And the Court of Justice, and we see this in paragraph 50 of the Court of Appeal's judgment, found that the condition in Coty satisfied the Metro criteria and so fell outside Article 101 altogether. And the Court of Justice, you can see by letter H, distinguished Pierre Fabre because there was no absolute ban on internet sales. And then if you look at para 51, there's reference again to Advocate General Val, but this time in the Coty case. He came to the same conclusion, but you can see the very final words of the page and over the page. So he found that Metro was satisfied, but he went on to consider whether if he was wrong and the restriction did fall within Article 101, so if Metro didn't apply, was it a restriction of competition by object? And he concluded that it didn't reveal a sufficient degree of harm in the same way as the absolute ban in Pierre Fabre. And that's a good illustration of the different stages of the test. So you might fail Metro, but you still have to consider whether there's an object restriction. Now, if we go to staying on page 391, so this is under the heading, the CMA's decision. So the CMA did find that the Ping online sales ban was restrictive of competition by object. And can I just ask you to, and this really fits with some of the points Lord Justice Green was just putting to me, can I just ask you to cast your eye over paragraph 56, because this summarises some of the factors that the CMA took into account. And you can see at little 3, for example, that Ping was the leading manufacturer of irons and woods in the UK with a significant market share. That the Ping brand was significant for a large number of retailers. Some customers didn't need to undergo custom fitting, and at 6, there was significant consumer demand to buy clubs online, and online sales were an important and established channel for golf equipment. And the policy restricted passive sales for Ping golf clubs, notwithstanding that advertising, the availability and price of the clubs, and making telephone sales were not prohibited. Price comparison was hampered by the absence of Ping clubs on price comparison websites, restricted the ability of retailers to make out-of-territory sales. And so you see there, just going back to my Lord Justice Snowden's question to me, it's not a full-blown effects analysis, but they're looking at the key features of the market. And then if we skip forward to page 393, we can see actually 394, from letter B to E, the CAT went through a similar process. So again, the CAT was there looking at some market factors. I'm showing you 56 and 66 because the Court of Appeal then comes back to refer to those in its analysis of whether or not there was restriction of competition by object.
Sorry, you want us to have a look at 66?
66, this is the CAT's summary of some of the relevant contextual factors. And then if we go forward to page 398, please, of the bundle.
Can I just ask you about one point from the CAT judgment referring to the amount of information about price and other matters on the internet?
Yes.
We should confess that we did actually look on the internet to see how much information you could provide about different shoes, and some of a portion of the bench are consumers of shoes for running purposes. It may not be in dispute, but we did look. You ought to know that. There does seem to be quite a lot of information about comparative prices if you want to go and look for it.
My Lord, quite right, and as you would expect.
It's not something we can take as a fact, of course, because CAT didn't really address that.
No, but it should have done, and that's.
Well, it's referred to as relevant here in the CAT's judgment.
It is, and that's one of the reasons why the complete ban on internet sales was restrictive of competition by object, because you can see not only did Ping have a big market share, so that its products were important to retailers, but it was actually quite difficult to find out about comparative prices. And not so here, and that, of course, you would expect it not to be difficult here in circumstances where all of the retailers in the selective distribution network can and do sell online. I think almost all of them have online sales.
I should just say that, just to be clear, I don't run in hawker shoes. I'm not conscious of
You should, my lord.
Well, maybe. I'm not conscious either of having bought any other brands on any of the parties' websites, so just to be clear.
Thank you. Now, can we skip forward, please, to page 398 of the bundle? And you can see from para 79 that the court then turns to consider the object question and applies the approach in carte bancaire. And you can see how they do that. And so just so you can see that the first heading is content of the ISP. Actually, before we do that, I've skipped over para 73. Can we just go back to that on page 396? The reason I'm taking you to that is because Pierre Fabre is a really odd judgment. It's very compressed. It's one of those Court of Justice specials. And it's pre-carte bancaire. And I remember thinking, I argued Ping, and I remember thinking it was an odd judgment at the time. But what the Court of Appeal is saying here is that whatever Pierre Fabre says, it's not taking a different approach to object restrictions. I just wanted to show you that.
Well, it refers to the four-part test content, object, economic and legal context.
It does, but then it spends a lot of time talking about legitimate aim and proportionality proportionate to a legitimate aim. And so the Advocate General, what the court surmises is that may have been part of the Metro analysis, but it can't be clear about that, and that's because the judgment is extremely opaque. And I just show you that in passing. And then going back to page 398, you have the 3 or 4 stage test. So content of the internet sales policy, and it was obvious what the content was. It was a ban. And then looking under that heading, you have reference on page 399 start on page 398. Refers to Advocate General Val talking about experience, so experience of the competition authorities, experience of the courts. So if a type of restriction is generally so harmful to competition that you don't need to carry out an effects analysis, you would normally tend to see some other cases establishing that. And so the court here refers to the Pierre Fabre case. And you see that on page 399. And then at page 400, the objectives of the ISP, and there was disagreement about what the objectives were. And at page 401, at paragraph 95, the well-established point that the party's intention is not a necessary factor in determining whether an agreement is restrictive. So you can take account of the subjective aim, but it's certainly not determinative. And of course, we say in this case, the tribunal placed a lot of weight on what it perceived to be DECA's objective aim. And then we have on page 402, at the top of the page, the heading Legal and Economic Context. Can I just ask you to read paragraph 97, including the citation of the Advocate General Bobek's opinion in that paragraph? So whole of para 97 to yourselves, please. Of course, we say that this is an important point. Not even when dealing with forms of conduct like price fixing, market sharing or export bans, which are generally recognised to be particularly harmful to competition, can the economic and legal context be totally ignored? Now,
well, can I just go back to the previous paragraph 45 that's quoted? I mean, the expression there is that there would be no legal or economic justification for prohibiting an agreement despite conforming to a category of agreements that is usually considered anti-competitive, is nonetheless, because of some specific circumstances, outright incapable, and it's the word outright. Does he mean obviously incapable? You know, in other words, just on its face, or just at first blush, clearly incapable of producing any deleterious effect? Is that really what he?
No, I don't think we can. I think that would be a gloss on.
Okay, what does outright? What does outright mean?
We probably have to look at the Hungarian original.
Yes, I mean, I don't. In a sense, I don't. It's only an Advocate General.
Because I saw, okay, but it sort of chimed a little bit, I thought, perhaps, with what I thought you were saying to us earlier. Just look at the very small market shares. It's just obvious this isn't going to have deleterious effect in the marketplace. But query, what does outright incapable mean?
So, my Lord, my submission is that there's not a test of it must be obvious from the economic context that it's incapable of having an effect. That would be a gloss on cut on care. But I do submit that it does all depend on the type of restriction you're looking at and the circumstances. And so if you have horizontal price fixing between competitors, then you'd really be looking for something very obvious in the economic context to say, well, hang on, that's not an object restriction, because it almost always is, because time and time again, the harmful effects to competition of that have been proven. There's lots of experience showing that that's detrimental to competition. And but if a clause is more ambiguous on its face, I don't mean ambiguous in terms of what it says, what it means, but ambiguous in terms of its potential effect on competition, then you would need to do a more thorough market analysis. And ultimately, this is why the court's talking about looking at experience. You are looking for something which is so obviously harmful to competition in the market that you don't need to carry out the effects analysis. And so if looking at an agreement in its legal and economic context doesn't drive you to that conclusion, well, then it's not an object restriction. You need to carry
it's
out.
whether you don't have to carry out the analysis. It is there are some agreements for which the economic effects are pretty much obvious.
Yes.
And I think that's pretty much what the court said in generics.
Yes.
When you're dealing with a dominant incumbent and very large multinational new entrants.
Exactly.
It sort of treated certain facts as almost common ground, and perhaps the same in Super League. When
Exactly.
you're dealing with, so it's that the facts are not really in dispute, and you can draw inferences from those facts without undue difficulty.
Exactly, but whereas here, you've got a vertical restraint, a selective
I agree.
distribution.
You say this is the other end of the spectrum.
The other end of the spectrum. So, but I don't, in response to you, my lord, I don't think it would be right to place weight on the word outright. Because,
what about basic reality check?
Because I think that would be a gloss on the test.
What about basic reality check? I mean, I'm just sort of getting. I mean, there seems to be a sort of, maybe I'm just getting the wrong end of the stick here, but there seems to be a sort of theme that if you're looking at an object restriction, you have to look at the economic context.
Yes.
And without conducting the full analysis that is required when you've got an effects restriction. There does seem to be this distinction, which is still... So it can only be a sort of relatively rough and ready examination of the economic context. And is this right? You only sort of reach... If you can say with a rough and ready look at it, first glance, basic reality or otherwise, or outright whatever, that it just isn't going to have an effect on the market, then it's not it doesn't infringe the objects test. I mean, am I oversimplifying it?
Well,
because I thought that's really what you were pretty much saying from the get-go here,
that
you're saying look at the market shares, look at the general context of this. This just isn't going to affect the market.
No, I think that's all I need to say in this case. I mean, is it a test of rough and ready? I mean, I'm not sure that the court in Carte Bancaire would agree that it's necessarily rough and ready. I think it all depends on the context. It depends on the kind of clause you've got. But you're right that it's looking at the key features of the economic context, and in a vertical case like this one, a very key feature is market share. So I think in our case, I'm happy with rough and ready.
I think that was Mr. O'Donoghue's sort of
yes, he
summary.
said basic reality check, and you see the court picking that up. That was Mr. O'Donoghue's submission at page 404. And so Mr. O'Donoghue was saying basic reality check, and the court there says, I don't see that a basic reality check would assist Ping in this case. There's nothing about the basic reality here that cast doubt on the conclusion. And here I told you that I took you to Paris 55 and 56 and 66. When it came to examining the legal and economic context, the factors that the CMA and CAT took into account are those I've described as Paris 56 and 66, which included market share and so on.
But what they're saying there is, on the facts of the Ping case, your basic reality check didn't lead you to say this, of course, isn't an object restriction.
It was an object restriction because...
it didn't lead you to say it wasn't. Sorry. In other words,
didn't preclude the possibility that there was an object restriction.
Exactly, didn't preclude the possibility,
but I think you are sort of urging on us a sort of approach which says in the instant case, our case, shoes, that a basic reality check is what was missing from the CAT's.
It's all missing, so there's no basic reality check.
Yeah, but that's what I thought your basic intro was this morning. Look, just the CAT never stood back and said, basic reality, is this going to affect the market?
Yes, I think that is my submission in this case. And the only reason I'm not wholeheartedly agreeing is that I just, carte bancaire doesn't talk about basic reality check or rough and ready. And so, but I agree. I
don't think anybody talks about
nobody talks about that. But I agree with you. It's not a full-blown. It's far from a full-blown effects analysis. You do have to look at the features, the economic features of the market, and ask yourself: is it obvious here that is there obvious harm to competition in this market?
But that comes back to the difference between object and effect. It's plain that you don't have to look at actual effects because, almost by definition, in a case there might be none.
Yes.
You might not have got to the point where something's implemented. But that's where I think the judgment of the Court of Appeal is relevant when they talk about the standard of proof, paragraph 111 onwards. So you've got to establish a real non-fanciful. The test was not a real non-fanciful potential or capacity. So you're not looking at potentiality.
Yeah.
It's more than that. It's whether the impugned measure revealed a sufficient degree of harm, not just that it had a sufficient degree of harm, not that a sufficient degree of harm was likely or non-fanciful.
Yes, exactly.
So you've got to get beyond speculation, but you don't have to go so far as to establish actual effects.
No, but the harm that's likely has to be serious harm to competition. That's what the case is. I showed you that in carte bancaire, and we can go back to it if you like.
Yeah.
Now, I said a few moments ago, we were looking at paragraph 97, which I think stimulated this series of questions. And can I just show you, because it's this point about needing to look at the market context is a point made very clearly by the tribunal in the Carbo case. Can I just show you that briefly? I know that is going to be, no doubt, I think is going to be on appeal on some points, but let me just show you in any event, because we say this is the tribunal applying the law correctly, and it's at Authorities Bundle 2, tab 14, and can we take it from page 540? And the case concerned a toy manufacturer, MGA, which entered into agreements with the most significant toy retailers that they should not stock the rival toy, the Worldies Globe. And if we look at page 541, so 540, you see the heading anti-competitive object or effect. If we go to page 541, you see at paragraph 381 that Mrs. Justice Bacon said that the transparent purpose of the agreement was to exclude Worldies from the market. MGA, so just pausing here, if the tribunal were right, and if Mr. Khan were right, then that would be enough. So it would have been enough for the tribunal, because here the tribunal said, oh, well, this was all about Deckers trying to suppress price competition, didn't go on to look at anything else. And if that were the correct approach, Mrs. Justice Bacon would have stopped there and said, well, the transparent purpose of this is to exclude a competitor, therefore it has an anti-competitive aim, and we can just stop. That's an object restriction. But that was not in itself enough to conclude that the agreements restricted competition by object. Because you see, there is discussion of the market, key market features. So the three retailers were the most important toy retailers in the UK. Successful launch of a new toy would be very unlikely if the product was not stocked by those retailers.
Sorry, I've lost where you're reading.
Sorry, 381, my lord.
Oh yeah, got it.
And then at 382, the consequence of the agreements was that the main and most important distribution channels were unavailable to the anchor product of the Worldies range, which in turn significantly reduced the likelihood of a successful launch and market recognition for the range as a whole. And so you can see that the judge is referring to the importance of the distribution channels that are being foreclosed, and also the importance of this product to inter-brand competition. And it's on that basis that the tribunal found that this restricted competition by object. And we can contrast, if we go to paragraph 386, the agreement with B&M in March 2018 was rather different. So even though that had the same transparent exclusionary aim, the judge found that by that time, Worldease had either been or was about to be discontinued by B&M, and Carbo's position was that the brand had failed by that point. The economic context of the market was therefore not such as to indicate a sufficient degree of harm to competition as to find that the agreement had as its object a restriction of competition. So you see the stages of the analysis, which are, well, yes, this has a subjectively, transparently anti-competitive aim, but you've still got to look at the key features of the market to demonstrate whether or not it's restrictive of competition by object. So it's two separate points. And our criticism of the tribunal's judgment is that it basically stopped short at the first point. It said this has a anti-competitive aim, there's no pro-competitive aim, therefore it's restrictive of competition by object. And
well, it used the answer to that question as the answer to the question whether there was it's a legal economic context. It elided the two. It said all you need to do is look at object, because a number of places they refer. Yeah,
exactly.
Yeah.
It under the heading legal and economic context, it just talks about the aim,
purpose. Yes.
Purpose.
And then when it looks at the facts, it doesn't look at the matters which the court identifies as relevant.
No.
Essentially, interbrand competition and levels thereof.
Exactly. And can I just show you, because paragraph 385 refers to the seafood and my fish case. And can I just show you that briefly? So that's in Authorities Bundle 1, tab 6, starts at page 78. And if we can take it from page 80. And so I'm just going to summarise paragraph 6 and 7, that the allegation was that there were anti-competitive agreements which comprised efforts by a supplier to prevent its retailers from dealing with one of its competitors. So the agreement was said to be an agreement, a vertical agreement, which foreclosed competition at the supplier level. And if we could go to page 96, this was a summary judgment. Paragraph 47. This is not a case in which Seafood's vertical supply agreements are part of concerted action by it and a number of its competitors. So pausing there, that's where there's a network of vertical agreements like that which facilitate horizontal collusion, that can be problematic. So this is a case in which the complainant will have to plead and prove the terms of the agreement, the economic and legal context of which it's part, and in particular the functioning and structure of the market identified in the counterclaim, with a view to establishing that competition in that market is significantly weakened. On the pleaded case, and on evidence so far adduced, and on the evidence which it may be anticipated will be given by experts who pay attention to the guidance of the relevant authorities, this cannot be established, even if one focuses tightly upon the anti-competitive foreclosure effects on potential entrants such as My Fish. My Fish, whose principals have an intimate knowledge of seafood suppliers and customers, identifies only one species of wet fish where its substitute supply is at a price higher than that payable by seafood, and adduces no evidence that, having regard to the functioning and structure of the market for the sale of wet fish and seafood to trade buyers, competition in that market is significantly weakened, bearing in mind that in a competition claim, one is concerned with the market as a whole and not with a particular business competitor. Again, we say that's the proper approach. This is not a rule of unfair commercial dealing. It's concerned with competition in the market. And that's what the CAT lost sight of. Now, can I show you, I've made the point now a number of times why the economic context of the market is particularly important in selective distribution cases, and really because they are generally pro-competitive and generally don't present risks to competition. Can I just show you the CMA's guidance on the UK equivalent to the vertical block exemption? So this is Authorities volume
We're looking
6.
at the VBE because of the timing of the facts, aren't we?
Exactly. So, and it's the 2010 VBE.
It's the 2010 VBE.
Yes. So I'm going to take you to that in due course. This is for a slightly separate point. So this is Authorities Bundle 6, tab 36. Can we take it from page 2291 of the bundle? Oh, sorry, wrong. Oh, no, that's right, 2291.
It's a snappy little document, this.
It's a snappy CMA special.
2291.
Yeah.
Yes. Now, I just want to show you what the CMA says here about what happens. So this is under the heading Selective Distribution Systems. You can see that at 2288 at the top of the page. And what the CMA is discussing here is what happens where the vertical block exemption orders, that's the UK equivalent to the block exemption we're going to be looking at, does not apply. And the CMA says that where it does not apply, the market position of the supplier and its competitors is of central importance in assessing possible anti-competitive effects, as the loss of intra-brand competition is only likely to be problematic where inter-brand competition is limited. The stronger the position of the supplier, notably above the 30% threshold, the higher the risk for competition resulting from the loss of intra-brand competition. Another important factor is the number of selective distribution networks present in the same relevant market. And it's talking there about cumulative effects of different networks. And the reason, now, this is about an effects analysis. So it's not directed to object. So it's about an effects analysis. But the CMA here is saying that a selective distribution system will only have the effect of distorting competition if the market has these characteristics. And of course, these same characteristics are highly relevant, as I've been submitting, for an object analysis, because, of course, the test for an object restriction is that the anti-competitive harm is so obvious that there's no need to carry out any effects analysis. Now, I said I'd take you briefly back to carte bancaire, so can I do that? We don't need to dwell on it for very long because we've looked at it in the context of the Court of Appeal's Ping judgments. That's in the second authorities bundle, tab 20. And I've shown you, if we go to page 924, I've shown you already paragraphs 51 down to 53. We saw that in the Court of Appeal's judgment. So
sorry, can you just give me the reference?
Of course. So it's tab 20, Authorities Bundle 2, page 925, and this is we're in the court's judgment here. And so I think you've seen already paragraphs 51 to 53. So talking about collusive behaviour which is so likely to have negative effects that it's redundant to prove actual effects, that's 51. And then 52, where the analysis of a type of coordination doesn't reveal a sufficient degree of harm to competition, then you need to look at effects. And then you've looked at 53 already, so necessary to take into consideration in context. I'm looking, so we were just talking about what do you look at, going back to Lord Justice Snowden's question, when you're looking at context, necessary to take into account the nature of the goods or services, as well as the real conditions of the functioning and structure of the market or markets. And then at 54, party's intention is not a necessary factor, but it's something you can, nothing to prevent you taking it into account. So it's potentially relevant but not determinative. And then we go over the page to page 926. At 57 and paras 57 and 58, the court found that the General Court had not taken a sufficiently restrictive approach to the concept of restriction of competition by object. You can see that at the beginning of paragraph 58. The General Court erred in finding that the concept of restriction of competition by object must not be interpreted restrictively. And then it says that it should be determined, it should be approached restrictively.
So, I mean, at the end of 57, just looking at what it actually said there, it's criticising the General Court because it said it didn't refer to the settled case law of the Court of Justice mentioned above, thereby failing to have regard to the fact that the essential legal criteria for ascertaining whether coordination between undertakings involves such restriction of competition by object is the finding that such coordination reveals in itself a sufficient degree of harm to competition.
Yes.
Just trying to pick up those words, in itself. I mean,
that means that you don't have to go on to look at effects. It's not.
Yeah, so it is sort of looking at the basic reality, just high level, first blush.
Well,
is it? Or I mean, what? I mean, again, outright.
Well, I think
what it all means.
All that's saying, I think, is that you don't have to go on to consider whether there are actual effects, because if you then look at paragraph 58, it's talking about. It says. Sorry, where was I?
Yeah, paragraph 58.
Yes,
only.
Yes, only to certain types of coordination between undertakings which reveal a sufficient degree of harm to competition that it may be found that there's no need to examine their effects. And so I think that's part and parcel of the same point. But what you've got at 51 down to 53 is the schema, as it were, which is that you've got to look at the content, and the context, and the legal and economic context, and the purpose of the provision, the objective of the provision.
No, but it's just I was just trying to get through it. Earlier on, you said, well, when I put something to you, you said, well, that would be an unwarranted gloss on this case.
Yes, I don't think you can read into reveals in itself the same gloss that the AG was using the term outright. I think all it's saying is that you've got to it's only certain types of coordination which reveal this sufficient degree of harm, without going on to consider the actual effects of the provision.
Yeah.
As always, this is a little bit of a tricky exercise determining exactly what's meant by some of this wording. Can I show you some of the Advocate General, just very briefly? So if we go to page 896, in fact, I've shown you that already in the Court of Appeal's judgment. That's paragraph 42, the point about market shares. And then if we go on, please, to paragraph 54, can I just ask you to read paragraphs 54 to 58, because that may help. As usual, the Advocate General, who was adopted by the court, or rather who was followed by the court, explains things a little bit more.
So you want us to go between where 54 and 59?
58, yes, the beginning of 59. So the Advocate General, again, is drawing the distinction that we've identified between object and effect. You don't need a full effects analysis, and the two things are separate. That explains that for that reason it's really necessary to take quite a restrictive approach to what is a restriction of competition by object. Can I just try and pinpoint, in light of these authorities, where we say the tribunal went, some of the places the tribunal went wrong on the law. So we can pick up the core bundle, tab 10. We've looked at some of this already. Page 145. So this is under the heading, the correct approach to the by-object assessment. And the tribunal correctly refers at 42, subparagraph 1, to carte bancaire as being the key authority. And then just going down, looking at, just pausing for a moment on subparagraph 4. I don't think the Commission, I don't think the tribunal means this, actually, to be fair to it. But if it's saying, so it says, both interbrand and intrabrand dimensions of competition are relevant, it is sufficient that an agreement has the object of restricting one of these two dimensions of competition to establish an infringement to the requisite legal standard. Now, if it's saying any restriction of intrabrand competition will do, that's obviously wrong. If it's saying it could be a restriction of intrabrand competition, all depending on the context, then that would be correct. I don't want to be unfair to it, but it's ambiguous. That's why I just point it out. Then we see at 5, vertical restraints are less likely to restrict competition by object. This principle is mirrored in the VBE, so we agree with that.
Just looking at subparagraph 4, as drafted, it's fairly unequivocal.
It is, but then if you look at paragraph 5, the reason I want to be fair is that if you look at subparagraph 5, it does say, in relation to the VBE, that so I don't know what the tribunal means by 4, but if it means
understood.
Then we see if we go over the page, we see at 7, resale price maintenance is understood to be restrictive by object in many, if not almost all circumstances. But then, interestingly, at 42.8, it says that even with resale price maintenance, you need to look at the relevant legal and economic context. And we agree. So the tribunal's directing itself correctly here. And then it goes wrong because of its interpretation of generics. So we've discussed generics, but the tribunal refers to generics at paragraph 43, and if we then go forward to paragraph 48, we can see the conclusion that the tribunal draws from generics, and it says this: where the only plausible objective the provision pursues is the restriction of competition, it necessarily falls within the scope of Article 101 as a by-object infringement. This is the point made by the court in Pierre Fabre, which was then fleshed out in generics. The absence of a legitimate aim provides the least contentious and most straightforward scenario of a by-object breach of Article 101.1, and that's completely wrong. So having set out the law correctly, carte bancaire, even if it's resale price maintenance, you need to look at the legal and economic context. It then goes badly wrong here. And really, if one has to identify, well, what blew the tribunal off course here, I think it may be this paragraph, because it then proceeded in its analysis, when we get later on in the judgment, its analysis of whether there is a by-object restriction. It proceeded on the basis that if there's no legitimate aim or purpose of the clause, then, hey presto, the clause infringes competition by object.
I mean, the 48 perhaps should be read with 46, which sets it up. So there is, 46, there is this qualification.
Yes.
Having regard to its content and the relevant economic and legal context.
That's fair, and my lord, I agree and that's consistent. Going back to the reference at the earlier point, which I think the tribunal set out the law correctly. So I took you to 42.8, which is correct. That's emphasising legal and economic context. And you're right that if you read 46 and 48 together, I mean, I don't like the last sentence of 48 because that really is looking at the subjective aim of a measure, I think. But if the tribunal had said, well, what we're looking at here is the object of the agreement, the economic object seen in its legal and economic context, I wouldn't have any quibble. But I think it's gone wrong in this last sentence of para 48. And having, as you say, my lord, set the law out correctly in the preceding paragraphs and sub-paragraphs, it then seems to have alighted on this point about absence of a legitimate aim, and then that colours all of the analysis later on in the judgment. So I think that's where it goes wrong.
In 48, it's the word necessarily in line 2.
Yes.
Because it then equates plausible objective restriction of competition equals breach.
Exactly.
And in 46, if you put the words having regard to content and relevant economic and legal context in parenthesis, it's clear that a provision restricts competition by object where it does not plausibly pursue a legitimate aim.
Exactly. And
its only plausible aim is therefore a restrictive one. So, I think as you say in your skeleton, they're eliding economic and legal context with subjective aim.
Exactly.
And absence of a plausible justification for the aim.
Exactly, and a plausible justification is relevant in Metro, but it's not the only factor. It may be a relevant factor because we know that subjective aim can be relevant.
It's admissible but not determinative.
Exactly, and that's really, I think, where it's all gone wrong. Shall I show you generics? I think you've got what we say about generics, but shall I show you? I think I will just quickly show you.
Probably.
Yeah.
Because the generics does spend quite a lot of time in dealing with object, but having also set out the 4-part test and saying that that's the basic reason.
Exactly.
And there's an explanation in the judgment for why they spend quite a lot of time looking at object.
Yeah, that's exactly. So my lord has the point, but let me just show you. It's in Authorities Bundle 3, tab 22, and also I think we need to go to it because Mr. Khan places a lot of emphasis on it. We can pick it up from, and of course the context was that this was a pay-for-delay agreement whereby the patent holder of a patented drug paid off generic companies that wished to enter the market with a generic version of the drug on condition that they agreed not to enter the market. And market entry with the generic product would have sent prices tumbling down dramatically. Now, if we go to page 1059, you can see at the bottom of the page, this is in the court's judgment, the heading, Characterisation of a Restriction of Competition by Object.
So the page was again?
Sorry, 1059, my lord, bottom of the page. I'm sort of locating the discussion, really. I just wanted to show you the headings. I'm going to go on to 1061. And you see lots of the familiar cases being referred to. So it's not the case, and I just make the point as a sort of a threshold point, that it's not the case that the court is doing anything different here, because you see carte bancaire referred to very squarely at paragraph 68, for example. But looking at paragraph 67, you can see there the court reiterating that the concept of restriction of competition by object must be interpreted strictly. And again, the reiteration of the carte bancaire test, looking at the content of their provisions, their objectives, and the economic and legal context of which they form part, is a sufficient degree of harm to competition. And then 68 refers to carte bancaire. You see the reference to the real conditions of the functioning and structure of the market and markets in question. And then 69 to 70. Can I just ask the court, can you read those paragraphs for yourself? And they really, the court there sets out some of the key features of the economic context, the structure of the market. And so just bearing in mind that what the tribunal says is, well, generic somehow changes things. You're not looking at market context. You're just asking whether there's a legitimate aim. And we say, well, not so. Look, these paragraphs are looking at the key features of the market. And if we go over the page to 1063 and look at paragraphs 81 to 83, again, the court there is explaining why settlement agreements, whereby a manufacturer of generic medicines that's seeking to enter a market recognises the validity of a patent rather than entering the market, is itself apt to restrict competition. It's liable to have effects that restrict competition, and that's because the patent, which grants a legal monopoly and allows a high price to be charged, will not be challenged. Lots of patents are invalid when they're granted, and the system depends on challenges to patents being brought. And if
50%, I think, isn't it?
Yes, yes, I think that's right, my lord. And so you can see why buying off that type of challenge is inherently likely to restrict competition. Again, that's another factor that these are important factors the court refers to. And then we can see that the court goes on to consider the possible justifications for this particular agreement. Because it might be that a settlement agreement of patent litigation is actually okay because the patent is strong and the parties have legitimately decided to settle. But you can see at paragraph 87 that the court finds there that from the analysis of that settlement agreement that it doesn't have any other explanation other than the commercial interest of both the holder of the patent and the party allegedly infringing the patent not to engage in competition on the merits.
I think that boiled down to the defendants were arguing that the agreement did no more than reflect the existence of valid patents. So it was an existence type exercise.
Exactly.
Dispute, which I think they cross-referred to the Advocate General, and she, I think, made that point quite explicitly, that even if ex hypothesi it starts as being a valid patent because it's been granted, that doesn't mean to say it will end up being so.
No, exactly so. And so the idea that this judgment somehow changes the approach to object restrictions, we say is just simply incorrect. We see the same, the court referred us to the Teva judgment. Shall I just show you that quickly? Because that's along the same lines as this one, and that's in the fourth authorities bundle, tab 29. And if we take it, that also, of course, concerned a pay for delay agreement, so similar phenomenon. And if we look at page 1532 at the bottom of the page, you can see that the first ground of appeal, the appellants are disputing the legal test used by the General Court to classify these agreements as restrictions of competition by object. And then you see reference to generics at paragraph 61. And that explains, paragraph 61 explains in the same way as I've just shown you in generics, why this type of agreement is inherently likely to restrict competition, because you're essentially stopping a potentially well-founded challenge to a legal monopoly. So it's obvious why this kind of agreement has the ability to restrict competition. But then the court goes on to say, well, some agreements like this might actually be legitimate. So even though they, as you see, they're liable to have effects that restrict competition, to use the wing at paragraph 61, they're not always restrictive of competition. And you see that from paragraph 63. That may be the case where the manufacturer of generic medicines receives from the manufacturer of originator medicines sums which correspond in fact to compensation for the costs of or disruption caused by the litigation between them. So it may be a genuine settlement agreement. And then 65, if that net gain from the transfers is not fully justified by such a need, it must be ascertained whether in the absence of such justification, those transfers can have no explanation other than the commercial interest of those manufacturers of medicines not to engage on competitions of the merits. For the purposes of that analysis, it's necessary to determine whether that gain including any justified costs, is sufficiently large actually to act as an incentive for the manufacturer of generic medicines to refrain from entering the market concerned. However, there's no requirement that the net gain should necessarily be greater than the profits which that manufacturer would have made if it had been successful in the patent proceedings. So it's not just the absence of a better explanation, but you need to be satisfied that the reverse payment is sufficient to incentivise the manufacturer to delay entry. And it's in that context that the court finds at paragraph 67 that it's clear that this type of agreement must be classified as a restriction of competition by object, where it's plain from examining them that the transfers of value can ultimately have as their sole explanation the commercial interest of these operators not to engage in competition on the merits. And so, in other words, this is just another instance of the carte bancaire analysis with specific guidance in relation to pay for delay agreements. So the court has explained why pay for delay agreements are inherently liable to restrict competition, but then they go on to say, well, is there a good reason for this one? That doesn't convert the carte bancaire test, it doesn't reduce it to a question of whether or not the agreement has a legitimate aim. So that's what I wanted to say about those cases. And I think on the law, the final thing to do is to go to the vertical block exemption and the guidelines, and then I can make my submissions relatively quickly because we've traversed a lot in discussion with the court. I've got up to 3:15 and we'll finish within that time, so we're fine for time. The vertical block exemption is in Authorities Bundle 1, Tab 3. This is the version in force. And if we can look at the recitals first and start on page 27. And you can see there at recital 6 at the top of the page that certain types of vertical agreement can improve economic efficiency. And 7, the likelihood that such efficiency-enhancing effects will outweigh any anti-competitive effects due to restrictions contained in vertical agreements depends on the degree of market power of the parties to the agreement, and therefore on the extent to which those undertakings face competition from other suppliers of goods or services regarded by their customers as substitutable. And then at 8, it can be presumed that where the market share held by each of the undertakings doesn't exceed 30%, vertical agreements which do not contain certain types of severe restrictions of competition generally lead to pro-competitive outcomes. At recital 9, above that market threshold, there can be no such presumption. And so you then need to carry out a full competition analysis. And at 10, this regulation should not exempt vertical agreements containing restrictions which are likely to restrict competition and harm consumers, which are not indispensable. In particular, vertical agreements containing certain types of severe restrictions of competition, such as minimum and fixed resale prices, as well as certain types of territorial protection, should be excluded from the benefit of the block exemption. And then you see at 12 that the market share limitation, the non-exemption of certain vertical agreements and the conditions provided for in this regulation normally ensure that the agreements to which the block exemption applies do not enable the participating undertakings to eliminate competition in respect of a substantial part of the products in question. And then if we go to the provisions, key provisions of the regulation, page 29, Article 2, you see that that pursuant to Article 101.3 and subject to the provisions of this regulation, it's hereby declared that Article 101.1 shall not apply to vertical agreements. This exemption shall apply to the extent that such agreements contain vertical restraints. And then at 2, the exemption, perhaps read 2 to yourselves, please. And then Article 3.1, you see the market share threshold. Again, if you could just read Article 3.1 to yourselves. And then Article 4 is headed restrictions that remove the benefit of the block exemption, hardcore restrictions. So the exemption provided for in Article 2 shall not apply to vertical agreements which directly or indirectly, in isolation or in combination with other factors under the control of the parties, have as their object. And then A, the restriction of the buyer's ability to determine its sale price without prejudice to the possibility of the supplier to impose a maximum sale price or recommend a sale price, provided that they do not amount to a fixed or minimum sale price as a result of pressure from or incentives offered by any of the parties. And so just pausing here, that's the resale price maintenance hardcore restriction, and it's a restriction on the buyer's ability to determine its price. Not something which changes the buyer's incentives, but its ability to determine its price. And what we're looking at is a fixed or minimum sales price. The imposition of a fixed or minimum sales price, either directly or indirectly. And that's why I say that the tribunal's finding here in relation to price, I'll come back after lunch to show you the relevant parts of the judgment again, do not amount as a matter of law to resale price maintenance, because there is no restriction there was no restriction on Up and Running's ability to price as it wanted, and indeed the tribunal found that.
So I think what probably that said against it at its highest is the question is, does it have as its object that result? And it does here, because it's known that the retailer would not, Up and Running, would not sell at such discounted prices from its main website, because that would undercut its current season.
My lord, I think that's what's said against me at its highest, and we say that that's wrong, and it's really important, we would respectfully submit for this court to tackle this question, because of course any selective distribution system, which as you've seen under the Metro line of cases, a key part of a selective distribution system is not selling outside the network. And so any time you impose that restriction and you've got retailers who are within the network and would have obvious incentives not to cannibalise their own sales, that could be said to be pressure with the object of keeping prices higher. But the test isn't, is there a provision which has the object of reducing price competition or softening price competition, because many provisions in a selective distribution system might be said to satisfy such a test. The question is whether it has the object of restricting the buyer's ability, nothing to do with their incentives. Are they able, if they want to sell at a lower price? And the answer here is yes. That's really the key point.
Up and Running would say, forget the position of all other distributors, but Up and Running says, no, because when we did try to do that through an anonymised website, we were terminated. So that did fetter our ability to determine our own price, albeit in a limited way that we've discussed because of the fact, not an anonymised website, not through its bricks and mortar, not through a branded, but yes, through an anonymised website, and that restricted its ability.
My lord, and we say no, that's not what's meant here, because Up and Running had an ability to sell at whatever price it wanted on its main website. Now, the fact that it may not have had the commercial incentive, the fact that it may not have wanted to do that, is not a restriction by DECA on its ability to price as it wanted.
It plainly wasn't a complete restriction, but it was a restriction on finding a way to the market, which wasn't through its main website for the reasons you've identified, through an anonymised website whereby it thought with impunity and without risking its other business, sell at a lower price.
But my lord, that's
maybe very limited.
That's not RPM, because the same could be said of
This isn't headed RPM. This is just ability to determine its sale price.
Yes, so the ability, so and that strictly means the ability, whether or not there is a fetter on the discretion of the retailer to sell as it wants, and there was to sell at a price it wants, and there was no fetter imposed by Deckers on its on Up and Running's ability to price as it wanted on its main website. Now, the danger of going further and looking at commercial incentives and looking at means of competing that might lead to lower prices is that if one goes down that road, then one is bringing potentially within scope of Article 4 all sorts of perfectly benign provisions of selective distribution systems. So take Coty, where Coty, the provision was that the website had to be a storefront of the store and had to conform to various elevated brand criteria. And what the retailer wanted to do was sell on Amazon, no doubt because it could sell more cheaply on Amazon. So it could equally be said in that case that precluding it from selling on Amazon meant that it couldn't sell at the price it wanted. But that's not right. It could sell at the price it wanted on its website. The fact that it may not be incentivized to do so is not a hardcore restriction. Otherwise, one is, as I say, bringing into this provision all sorts of selective distribution system restrictions, which are really a necessary and inherent part of a selective distribution system. And this is, I think, a key error in the tribunal's reasoning. I'll come back to make some further submissions about that. The other provision relied on by the tribunal as precluding the application of the block exemption is 4C. So if you look down the page, the restriction of active or passive sales to end users by members of a selective distribution system operating at the retail level of trade without prejudice to the possibility of prohibiting a member of the system from operating out of an unauthorised place of establishment. Now you might think, well, we're within the without prejudice here, but this was, and I'll come to make submissions about this, wrongly deemed by the tribunal to be applicable in the present case, and they held that because of the way the clause was enforced in this case, that restricted passive sales to end users. But that's not the right way of looking at it. It's not the right way of construing this clause. Sales to passive users were not inhibited because they could sell as much as they wanted on their main website. My lords, I was going to take you to the vertical restraints guidelines, but it's probably best to do that after lunch, looking at the time.
At some point, I don't think there's any disagreement about this. Just we would like to ensure that we have everybody's clear submission as to the legal precedential effect of various CJEU cases. So we're not bound by CJEU cases post-departure. Which cases are we bound by and which aren't we?
Okay.
And I think as far as the VBE, I mean, that's applicable because it was applicable
at the time.
At the relevant time.
Yes. Thank you. We'll address that too. Thank you.
Right.
2 o'clock.